Welcome and thank you for joining us today. I'm Lucy Claridge, Head of the Strategic Legal Response Centre at Forest Peoples Programme, and today I have the privileged role of moderating this webinar in which we are joined by a very distinguished panel of Indigenous leaders from around the world. Before we move on, however, I'd like to briefly explain the format of the event and how you can ask questions. Our panellists will all be speaking for the first 40 minutes and then taking questions from the floor for the remainder of our time together. To ask questions, please submit them via the Zoom platform using the Q&A function on your screens. And if your question is intended for one participant in particular, please include the name of the speaker. I will now pass over to my co-host, Meg Satterthwaite, for a brief introduction.
Good morning, good afternoon, and good evening to all of you who have joined us online. It's my great pleasure to welcome you all to our webinar today, entitled Strengthening Indigenous Voices, Legal Empowerment and Community-Based Methods for Advancing Access to Justice. My name is Meg Satterthwaite, and I am Director of the Global Justice Clinic, one of the co-sponsors of this event, along with Indigenous Peoples' Rights International, the Forest Peoples Program, and the Center for Human Rights and Global Justice at NYU. We have an incredible panel and a talented moderator, and I'll turn over things to them in just a moment. But before we begin, I would like to acknowledge the traditional, ancestral, unceded territory of the Lenape people on which I work today at NYU School of Law. I recall and acknowledge that Lenape collectively are a living community. I hope that our discussion this morning will advance work against the forces that have dispossessed the Lenape and other Indigenous peoples of their lands. One way we work against these forces at the Global Justice Clinic is through legal empowerment partnerships. These relationships, including one with the Indigenous South Rupununi District Council in Guyana, are aimed at supporting the work of the communities who are advancing their rights on their own terms, while strategically taking up the tools offered by the formal legal system. Accompanying communities is a small part of their work, and the Global Justice Clinic is proud to lend our support through methods that help communities to know, use, and transform the laws that impact their lives. We're sorry that our colleague Gavin Winter of the SRDC can't make the panel today. He sends his regrets. Although we're sad that Gavin could not join us, we're thrilled to have such a wonderful panel today. I'm happy to hand the floor to Lucy Claridge, who is Senior Counsel and Head of the Strategic Legal Response Center at Forest Peoples Program. Lucy will lead us throughout the rest of today's webinar. Thank you.
Before we begin, just a reminder that simultaneous translation is available in Spanish and English. Please go to interpretation in the meeting controls and select your language. So firstly, I would like to extend a very warm welcome to Daniel Kobei, Executive Director of Ogiek Peoples Development Programme. Daniel is the founder of the Ogiek Peoples Development Programme, a Kenyan-based NGO working to secure the human and land rights of the Indigenous Ogiek community and other Indigenous peoples across Kenya and Africa. He represents Indigenous peoples under the umbrella of the International Indigenous Forum for Biodiversity, set by the Convention of Biological Diversity. He is also an Indigenous human rights defender, leading the Ogiek to win an 8-year legal battle over land and human rights abuses at the African Court on Human and People's Rights in May 2017. He has been promoting the restoration of the Mau Forest Complex through Ogiek community involvement as a forest-dwelling hunter-gatherer community. Daniel, you have the floor.
Good evening, good afternoon, and good morning, everybody. As Lucy has introduced me, I'm Daniel Kobei from here in Kenya, and I'll try my best to go and share a few thoughts about the situation. And I'm happy for Meg when he was really acknowledging the ancestors and the traditional people in New York, and wish to really acknowledge the Ogiek community, our ancestors who have gone struggling and fighting for the rights of the Ogiek community and other indigenous people globally. So I'll be sharing my screen on which, I don't know whether you're able to see. Are you able to see the screen?
Yes.
Okay, thank you. Yeah, at least there should be a bit of communication so that I might be talking and nothing is going on. So I will be taking you in a brief, because the issue of Ogiek community and the struggle for their land rights takes over 20 years. So if I have to talk of a story of 20 years, you can imagine how long it will be. So today I will only try and give a brief of the situation on the legal process and the implementation and the cohesion and the kind of tenacity we have had as Ogiek community. If you see the first photo is Ogiek women demonstrating. You can see the majority are Ogiek women, which they were demonstrating not long ago, even amid this when COVID was already on. This was done in near Nakuru here. And they were demonstrating because of the harassment of police and eviction which was taking place in Mau Forest Complex. So you could see the kind of strength and the courage our women have had, and this has taken time before they came up. Previously, Ogiek women, it was not easy to see them, but most recently they have become more courageous, more strong, advocating for their rights as a Ogiek community. And OPDP, the organization which I work with, Lucy mentioned, was formed in 1999, registered in 2001, and basically fighting for the Ogiek community in terms of economic, social, political, land issues, and of course, cultural issues of the Ogiek community. And a brief history is that the Ogiek community is currently a population of 52,000, of a majority of about 45,000 reside in Mau Forest Complex, which is over 400,000 hectares. It's a big land, and some of them are in Mount Elgon. Some of the areas where they are, I've already listed: Nakuru, Narok, Kericho, Baringo, and some in Mount Elgon, Nandi, and Bungoma. So as a community, the flow of events in the process of litigation, in that in 2009, the government of Kenya gave a 14-day eviction notice in 2009. And this made me and some of the Ogiek community to seek intervention from the African Commission on Human and People's Rights. That is when we were joined in by Semi-Right. That time we had somebody called Kolisingoya, and later on by Minority Rights Group International, which by then Lucy was there. And we started now advocating and asking that how can you evict people in 14 days when they have been there for centuries? So this could not really add up. So that is when now the process. And as they were doing that, the Ogiek community had already been in court since 1997. So having been in court since 1997, and now they have already, they didn't acknowledge or protect this issue of this particular case from 1997 to date. Now again, they have gone ahead wanting to evict them. So this took us now to the African Commission for over almost 2 years. Then in 2012, we went to the African Commission, transferred the case to the African Court. So that is then we went for hearing in 2014 at the African Court in Addis Ababa. So that one was done on 28 and 29 of 2014 in Addis Ababa. And some of us, you can see a picture of us standing outside the African Union in Addis Ababa. So you could see the duration from 1997 to 2009. This is Ogiek have been in and out of court. In all this, they've been struggling for their rights. So the community main aim was is to ask for the government to evaluate some of the articles of the African Charter on Human and People's Rights relating to Article 4, 8, 14, 17, 2 and 3, and Article 22. And of course, the issue of natural resources, which we'll be able to discuss more on that. So as I had mentioned, I think I mentioned about 2009 and 2012 when we went to the African Commission and when we went to the African Court. And going to the African Court was basically, if I recall very well, I was not one of the people who liked going to the African Court. And I remember calling Lucy and Korir, asking them, why are we going to the African Court? We should have remained in the African Commission. They said we are better off being in the African Court than being in the Commission. And that is when now in March 2013, the African Commission themselves said, because of mass violations, let's transfer this case to the African Court. So that is now when the process started. And that is the case number, that is 006 of 2012, about the African Commission on Human and People's Rights versus the Republic of Kenya. So there were a lot of events which took place, which some of them I may not go through them because of time. I'll try to see that. But the African Commission, the government immediately stated the restrictions. There were African Court issues calling for provisional measures, or rather to stop any further eviction, any further issues going on in Mao. And they were told that these orders will start taking place immediately. So later on, the government of Kenya, of course, write letters saying we are complying, we are compliant. Of course, sometimes not the way they write, but that's it. So you could see on the 27 and 28, when the public hearing was going on in Ethiopia, one of the witnesses, which was an Ogiek woman and an Ogiek man plus one expert in land and natural resources. Of course, on 26 May 2017, the African Court delivered the judgment. You could see the government was declared, the Kenyan government violated Article 1, 2, 3, 8, 14, 17, 2, and 3, and 21 and 22 of the Charter by evicting the Ogiek from the ancestral land and making all sorts of violations which took place. However, it concluded that the government did not breach Article 4, which of course we were not able to prove that there were deaths, and how we could not prove to the court that deaths took place. And after that, the court directed the government to institute appropriate measures within a reasonable time frame to remedy all violations committed, which of course they've been trying to form what we call task forces after task forces, but nothing much has been done. And of course, again, they were to submit a report within 6 months from the date of the ruling, which now, since 2017 to date, we are almost saying almost 4 years since that, and nothing much has been done. So you could see the Ogiek people sitting in the court, many things, and the kind of reparations we were given 90 days, and there were extensions, and I may not be able to say much from there. The status of implementation is that the community submitted the reparations, which we are done, and we are waiting for the hearing. The government responded while dismissing some of them, of course. Community referred giving clarity on the reparations. On November 10, 2017, the government gazetted 17-member task force to give guidance on the implementation process. However, the term expired in May 2018 without accomplishing the outlined task. November 2018, the new task force headed by Dr. Robert Kibuki, appointed by the Cabinet Minister for Environment and Forestry, Patricia Tobón, was mandated to coming up with recommendation on the same of the African Court ruling to meet all stakeholders, including Ogiek and indigenous peoples, organizations, civil society, academia, among others. So the task force, you could see the task force listening to us on Wednesday 6, 2019 in Nakuru here, and the meeting was held. Over 2,000 Ogiek attended, which was one of the well-attended court task force meeting ever. The task force received views from Ogiek in form of memoranda and verbal submission from the community members. So you could see us presenting the memorandum to the task force with all the Ogiek leaders there. And then, so it talked about the restitution of the ancestral land for us to be returned to the Ogiek community, no commercialization of Ogiek rights, and then safeguard forests against encroachment, Ogiek to help in government to restore the forest, recognize Ogiek as a people with unique interactions and have a strong will to safeguard forest, and as also we so that more be returned as a communal land, and also a benefit sharing arrangement for the resources accrued from Mao. Compensation of all the damages, formal entitlement reflecting ancient territorial arrangement, value of Ogiek indigenous knowledge, habitation limited to agreed upon area, each community divine community forest reserves, operational community land act 2016, and members of each Ogiek community has to have their own right relating to the land ownership. So you could see some of the Ogiek women making the presentation during the task force meeting, which is one of the strengths we have had, where women have really been involved in strengthening the process of implementation. So on 26th May 2018, every year we celebrate or commemorate the day, and that's why you could see us celebrating on 2018. Fortunately, that day Lucy was able to join us. That was great, and many other government officials managed to join us. So in this case, we have been only calling the government to fast track the implementation of the case, which sometimes they have not taken it, and we could see that there is a lot. We have also had a lot of proactive actions toward implementation, where we have had support from minority indigenous peoples in Kenya and across Africa for the purpose of advocating for the effective execution of this particular case, because this was a landmark case, and we expect it to be implemented so that it can also be useful in other parts of Africa and beyond. Despite of all this, we have also had challenges. You could see some of the, just a minute. You could see some of the challenges facing the implementation of the Ogiek is that you could see some of the forest guard burning some of the houses belonging to the Ogiek community. So they have been delayed by the Kenyan government in implementing the case, lack of political will, which is also one of the issues which are really denied us, human rights violations, profiling and criminalization of Ogiek human rights defenders, limited resources, sometimes to do some of the work which is expected, and circulation of fake title deeds, which are now creating conflict within Ogiek and other communities, and many other masquerading as Ogiek just because they want land. So as I'm about to end, I could say, you could see the strength of women once more and young people trying to support to ensure that this particular issue, and even during the meeting recently for Women's Day, and they really advocated that the Kenyan government should fast track in implementation of this case. So I think for now, I wish to end there, and I hope I'm within time. And I think most of the things will be where questions and can be asked. And then from there, we can move. Asante sana. Thank you very much. Some of the contacts are there in case anybody also wants to contact us, and I'll be able to share the presentation to Lucy. Asante sana.
Thank you very much, Daniel, for your words on how the litigation process has empowered the Ogiek, but also the challenges that your community has faced along the way. I think it's a story of great tenacity, and I know it's an ongoing journey, and a journey that you've also heard is close to my own heart. So I'd now like to introduce Vicky Tauli-Corpuz, our next panelist. Vicky is an Indigenous activist from the Kankana-ey Igorot people of the Cordillera region in the Philippines. She's a social development consultant, a civic leader, a human rights expert, a public servant, and an advocate of women's rights. As an Indigenous leader, she actively engaged in the drafting and adoption of the UN Declaration on the Rights of Indigenous Peoples in 2007. She served as the chairperson of the United Nations Permanent Forum on Indigenous Issues from 2005 to 2010, and as the chairperson rapporteur of the Voluntary Fund for Indigenous Populations. She was appointed as the UN Special Rapporteur on the Rights of Indigenous Peoples from 2014 to 2020. Vicky, you have the floor. Thank you.
Thank you very much, Lucy. And thank you very much to the Organizations Forest Peoples Program, especially in organizing this event. I was asked to speak about the right to self-determination and access to justice by indigenous peoples, which is of course very relevant for this Ogiek case, as well as the case in Colombia that we're going to hear later. But I just want to share a little bit about the contents, the main contents of my reports relating to the right to self-determination and the right to self-government and autonomy, as well as access to justice and the use of indigenous justice systems. In my role as the special rapporteur, I looked at these issues very closely, mainly because, of course, the right to self-determination is really the foundational principle that underpins the UN Declaration on the Rights of Indigenous Peoples. No, and if you are familiar with the UN Declaration on the Rights of Indigenous Peoples, Article 3 of the Declaration says that Indigenous peoples have the right to self-determination, and by virtue of that right, they have they can freely determine their political status, and they should freely pursue their economic, social, and cultural development. And the next article that comes after that is Article 4, which talks about the right of indigenous peoples to self-government and autonomy, and that they also have the right to have the financial means provided by government to be able for them to effectively operationalize their own self-government. No, and so this is really a foundational right, and this is one of the collective right. This is the collective right that has been asserted by indigenous people since the beginning of the drafting of the UN Declaration, which started in 1985. I have been part of the whole process until its adoption, and so I'm familiar with all the arguments that have been used by most governments to convince us that we don't have the right to self-determination. But of course, the indigenous peoples asserted that they have that right, and these rights are also recognized in the legally binding treaties, like the International Covenant on Civil and Political Rights, the Article 1 of that covenant, as well as the International Covenant on Economic, Social, and Cultural Rights. It's also Article 1 of that particular covenant. The other convention, the International Convention on the Elimination of All Forms of Racial Discrimination, also has Article 5, no, which acknowledges that there is the right to self-determination, no? So of peoples, and the African Charter on Human Rights and People's Rights as well recognizes this collective right, no? They recognize that peoples have the right to determine how to dispose and use their natural resources and their wealth, no? As well as the right to publicly participate, no, in governments. So this is a very important right that that indigenous peoples themselves have asserted and claimed, and it should be understood very well by the dominant society and by governments. In my reports, I have stated very clearly that the recognition of this right by the states is really a major step in ensuring even the creation of a society, of the nation, which is more inclusive and which will be strong, because indigenous peoples have been contributing to not only to development, but also to the environmental sustainability, really can contribute significantly to sustaining the nation and making it stronger. So I called for an intercultural dialogue between indigenous peoples and governments to further pursue, how to implement this right. Of course, one of the rights, as I mentioned earlier, is the access to justice and the right of indigenous peoples to use their own justice systems. No, so it is recognized that indigenous peoples have been discriminated, no, since time immemorial against by the ordinary or the justice system that has been set up by the nation states. And in many cases, they don't recognize the justice system that indigenous peoples have. But in the reports that I made, I clearly stated that access to justice is a right of indigenous peoples. And this is one of the reasons why indigenous peoples have gone to the courts as well as to the grievance mechanisms or complaints mechanisms of the UN, you know, like the treaty bodies or our special procedures, like my mandate as a special rapporteur on indigenous people's rights. And these are the mechanisms that indigenous peoples have been using to be able to get a better justice for themselves. And I know in this Ogiek case, I was asked to make a comment on it as well. So I did several comments which I presented to the African Court on Human Rights. I think the important, the cross-cutting elements of the right to self-determination are all contained, you know, also in the declaration. The first cross-cutting element is, of course, the right to lands, territories, and resources. No, you cannot really be self-determining if your right to your lands, territories, and resources are not recognized and are violated. And clearly, for the Ogiek case, this is the situation. No, they have been asserting that they have their rights over these lands and territories, and that they should not be displaced from these territories. Or they should not be they should be allowed to determine how these territories are going to be used. So in many cases that I have seen, usually the violation, no, of the violation of the rights of indigenous peoples to the rights to their lands, territories, and resources is the most common one that we see. No, and in connection with this is the right of indigenous peoples to free, prior, and informed consent. No, in the UN Declaration, there are, I think, 4 or 5 articles on which are affirming the rights of indigenous peoples to their lands, territories, and resources. But there are 6 articles that also define and that also affirm the right of indigenous peoples to have their free, prior, and informed consent obtained before anything any project, so-called development project, whether government or run by corporations or others, are being brought into their territories. No. And again, this is a very common violation because governments behave as if they can be the ones who just determine what to do with the territories of indigenous peoples, and without asking their consent or their informing them about the projects, they just go and impose these projects. And for many countries that I have seen, this has been the beginnings of major conflicts, which are continuing up to now. No, so that free, prior, informed consent is a very important element of the right to self-determination. No. Thirdly, the recognition of indigenous authorities and institutions, no, and this is the right to self-government. As you know, many indigenous peoples, I mean, even before there were governments, they were already governing themselves. No, even before colonization, they have set up their own governance systems which govern themselves, because otherwise, how can they live peacefully amongst themselves and between themselves and their neighbors? So that was developed, but many of these got destroyed when colonization came and when the nation state started to be set up, to be established. But indigenous peoples in several parts of the world continue to govern themselves. And I've seen this in Latin America and several countries in Asia. And I'm sure also in Africa, you know, indigenous peoples have their own systems of governance. And these systems of governance that they have set up and that are still working should be supported, no, by the states. The fourth element are the ways and means for financing indigenous peoples' autonomous functions and achieving the right to their own development. No, And this is where again the Ogiek case comes in, because if the ruling of the African court will be implemented, of course they will be needing all the resources for them to be able to manage more sustainably and strongly their own territories, no? And so this ways of financing is an important element, and the government, the states, the nation state should really support them. I've seen situations for instance, in Ecuador, where the indigenous peoples have asserted the right and their self-governance, and they were the ones who have developed their own indigenous schools and even universities, and they have been running these. Unfortunately, along the way, the budgets for these kinds of institutions have been taken away, no? But they are still asserting this up to the present. I've also seen several places in Colombia, for instance. I went to in the Sierra de Nevadas, no? And I saw the people there, the traditional authorities are also the justice authorities who have been governing their own communities, no? So this is in the concrete what right to self-determination means, no? That you are able to really determine your political status, freely determine your political status, meaning to say what is your relationship with the existing state, no? You can and also freely determine your economic, social, and cultural development. And for you to be able to do that, your rights to your lands, territories, and resources have to be recognized, as well as your right to free, prior, informed consent, and the right to publicly participate, if you so choose, with the dominant government is also part of that right. No, and of course, as I mentioned, the resources should be made available for you to be able to assert and assert your governance systems and govern yourselves. No, and so I think that to relate it to some of the cases that we're going to mention, if there are court decisions that have been made in favor of indigenous peoples, by all means, this should be implemented. And that's the sad reality in many parts of the world. There are very good decisions, even in Latin America, no, very favorable decisions for indigenous peoples that have been decided by the courts, but the states who are supposed to implement these decisions are not doing it. I was a friend of the court in Costa Rica, in the Inter-American Court on Human Rights, and this was the case of the Kalinya and Lokono peoples who filed a case against the government because they allowed mining in the territory of indigenous peoples, which also happened to be a protected area. No, so I was the friend of the court. I mentioned that the rights of indigenous peoples, and eventually the court decided in favor of the Kalinya and Lokono peoples, but up to now the implementation hasn't happened. No, it's not happening to the satisfaction of indigenous peoples. So I think I would just like to end by saying that, so that's precisely why legal empowerment is really very crucial, no, for all the work that indigenous peoples are doing, and the use of these justice systems should be accessed by indigenous peoples. But more importantly, indigenous peoples and their allies should really do all the best effort that they can to be able to get these decisions implemented that were decided in their favor. No, it's a long process, as we have heard Daniel speak. The process of getting favorable decisions for indigenous peoples takes years, and yet after the decisions have been reached, they are not being implemented. So I think that's the challenge that we are facing now, and hopefully with all the allies that we have around us, the support groups like Forest Peoples programs, we will be able to get some of these decisions implemented for the sake of the survival and the dignity of indigenous peoples. Thank you very much.
Thank you very much, Vicky, for sharing your vast knowledge and huge experience with us, for explaining the importance of Indigenous governance and justice systems, and for really emphasising the need for court rulings to be implemented, which I wholeheartedly agree with. We will now turn to our final panelist, Patricia Tobón, who will draw on her experience with transition and truth commissions in Colombia as a method to determine rights to land and build solutions. Patricia is a Colombian Embera indigenous lawyer. Currently, she is one of the 11 members of the Colombian Truth Commission, which was created after the peace agreement signed by the Colombian government and the FARC. Patricia is also one of the founding partners of Akubadaura Attorneys Community, a collective of indigenous lawyers and journalists created to work with indigenous communities in cases related to protection of their rights. Patricia has testified before the National Indigenous Organization of Colombia and before the Inter-American Commission on Human Rights on the effect of natural resource extraction and violence on indigenous communities, with a particular focus on indigenous women. Patricia, you have the floor. Thank you.
Bueno, buenos días. Muchas gracias al programa Forest People por invitarme a participar de este evento importante. Saludos también a los panelistas y a Victoria. Qué alegría. Bueno, a mí me invitaron a hablar sobre el tema de la justicia comunitaria en diálogo con la justicia transicional del proceso y acuerdo de paz último que firmó Colombia con de las FARC, pero que también incorpora a muchos otros grupos también armados. Yo antes de comenzar quisiera contar que en Colombia existen 115 pueblos indígenas. Esos 115 pueblos indígenas, discúlpenme, no sé si tienen la presentación, bueno. Tenemos 115 pueblos indígenas, de los cuales 37 pueblos están en riesgo de desaparición física y cultural como consecuencia del conflicto armado. Pueblos indígenas que en el marco de la pandemia pues tienen una situación más delicada todavía porque han sido afectados por la pandemia de manera grave, pero también por la afectación del conflicto armado, que es una realidad en sus territorios. 22 territorios y rutas del conflicto armado que tiene el país, 17 de ellos están sobre territorios de las comunidades indígenas. En Colombia, el conflicto armado se ha concentrado en el territorio étnico y en el territorio indígena. Eso es una realidad. El 30% del territorio nacional son territorios pertenecientes a los pueblos indígenas y el 50% de los bosques del país están en esos territorios. Y precisamente por esa gran, digamos, diversidad de recursos, pues hay una disputa por el control territorial de los bosques, de los recursos naturales, de economías legales tanto ilegales, y también una realidad es que los territorios indígenas están en zonas de frontera, es decir, es todo el cordón de todo el territorio nacional y comunican a muchos lugares del mundo, comunican en la región pacífica con todo el eje pacífico, comunican hacia el norte, están los dos, digamos, océanos en esas costas, territorios, y eso, digamos, ha generado disputas de poder entre diferentes grupos armados para asuntos de narcotráfico, pero también asuntos de armas, pero también diferentes tipos de economías legales y también muchos proyectos de infraestructura. Entonces hay una disputa por esas tierras, históricamente un conflicto asociado a estos intereses. Del mes de agosto del 2016, que es el mes en cual se firma el acuerdo de paz, al 17 de marzo del año 2021 se ha contabilizado 323 asesinatos de líderes indígenas en Colombia. El reconocimiento de los derechos de los pueblos indígenas en Colombia ha permitido una mayor exigibilidad por parte de los pueblos indígenas, y esos son hitos importantes en los procesos no solamente de exigibilidad jurídico, sino en varios de los asuntos que les voy a mencionar. En 1991, Colombia incorporó los estándares del convenio 169 de la OIT en la Constitución Nacional, y eso permitió reconocer unos estándares al reconocimiento de la diversidad étnica y cultural del país, el reconocimiento de las autoridades étnicas en la administración de la justicia, el reconocimiento que tienen a la protección de sus derechos territoriales, a un desarrollo diferenciado, e incorporar el 169 como convenio que hace parte de la Constitución Política de Colombia. También la Declaración de Naciones Unidas sobre Derechos de los Pueblos Indígenas ha sido un hito importante, aunque Colombia no ratificó el convenio, la declaración sí que es importante en la jurisprudencia de los jueces de las Cortes colombianas, y también ha sido importante para los pueblos indígenas en la exigibilidad de estos derechos ante las instituciones y ante la sociedad, y también para la construcción de sus propias agendas en la reivindicación de sus derechos. El efecto de esos reconocimientos de derechos en la acción ante las Cortes, pues se comenzaron a ver a partir del año de 1992, un año después de que está aprobada la Constitución del 91, sobre todo en la Corte Constitucional colombiana. Empezaron unos primeros casos, como fue el caso del pueblo Uva, que hizo una demanda a la petrolera, a la empresa petrolera nacional y a la Occidental. Es un caso muy importante porque es el caso donde ellos piden la suspensión de una exploración y las concesiones petroleras que se hacen encima de sus territorios. Llevaban mucho tiempo los UBA haciendo procesos de movilización social, pero fue esta demanda la que permitió la suspensión de la, digamos, explotación petrolera en su territorio. Está el caso Urrá, que fue, digamos, de manera inconsulta y sin la participación de las comunidades, y afectando de manera grave a las comunidades del pueblo Embera, se hizo una represa Urrá, una represa que canalizó el río y que pues desplazó muchísimas personas de las comunidades indígenas del pueblo Embera. Y acá hubo todo un debate del país frente a los proyectos de infraestructura, pero sobre todo hubo una demanda en la que la Corte Constitucional obliga al Estado y a la empresa a hacer un proceso de reparación al pueblo Embera, aunque esto tiene pues lecciones difíciles, duras. Los efectos de la represa de verdad generaron afectaciones muy graves de las cuales el pueblo no se ha repuesto. Sí es importante mencionar que la sentencia en sí misma es un hito muy importante porque hablan de responsabilidades de las empresas y responsabilidades estatales, y también previene, digamos, la ampliación de la represa en esta región. Otro hito importante fue el caso de la comunidad Urada Jiguamiandó, en el cual la empresa Muriel Mining Corporation hace una consulta, hace unos acuerdos con algunas autoridades para hacer un proceso de prospección y explotación minera en un territorio que es sagrado también del pueblo Embera. Y acá es muy importante esta sentencia porque a pesar de que el documento fue firmado por unas autoridades, la Corte Constitucional hace valer el derecho de todo el pueblo como colectivo, de que este es un territorio colectivo, que si bien hay representantes de pueblos indígenas, estos no pueden menoscabar los derechos colectivos que tienen los pueblos en sí como colectividad, y que en ese sentido una consulta no puede entenderse como realizada porque simplemente la firman unas autoridades, sino que requiere el consentimiento del pueblo. Y eso también suspendió lo que fue el proceso de exploración y explotación de un gran territorio que hoy es un territorio pues de reserva y de biodiversidad del planeta y de estas comunidades. Está un caso que fue la demanda del Plan Nacional de Desarrollo. Este es un caso muy importante en el año 2011, en el cual los pueblos indígenas demandan el Plan Nacional de Desarrollo de esa época porque no se construye con la participación de los pueblos indígenas de Colombia, porque gran parte del Plan Nacional de Desarrollo colombiano está diciendo y tiene que va a intervenir los territorios de pueblos indígenas y que va a afectar, digamos, desde la visión indígena esto gravemente, sus derechos a la participación y a sus territorios. Y la Corte Constitucional aprueba que desde entonces los planes nacionales de desarrollo en Colombia tienen que tener la participación y consulta a través del mecanismo que los propios pueblos indígenas crearon en el año 1996, 5 años de la Constitución Política de 1991, los pueblos indígenas crearon una mesa de concertación de pueblos indígenas entre los pueblos indígenas y el Estado colombiano para hablar sobre el relacionamiento de cómo van a ser las políticas del Estado con los pueblos indígenas. Y este era un espacio que no había tenido realmente atención del Estado. Y fue a través de esta sentencia en donde se dinamiza casi todos los diálogos de la construcción y debates de políticas públicas y de diálogos entre el sistema occidental y las autoridades de pueblos indígenas. Y está el caso también de la sentencia de un proyecto de ley sobre desarrollo rural, un estatuto de desarrollo rural para, digamos, entregar tierras de reservas a, digamos, a empresas en las que las autoridades también le piden a la Corte que esto se suspenda hasta que no se surta la consulta, lo que, digamos, incorporó necesariamente en todos los debates agrarios del país la necesidad de que se surta el procedimiento de diálogo y participación con las comunidades indígenas. Y esos efectos de reconocimiento entonces de derechos se vieron también en aspectos como en Colombia todos estos procesos de litigio. Quiero decir que la Corte Constitucional tiene más de 87 sentencias que se refieren a aspectos de los pueblos indígenas en los cuales ordena a diferentes instituciones respetar los derechos constitucionales, a la participación, a la consulta, al territorio, porque la Corte eleva en todos estos pleitos jurídicos, que muchos de ellos fueron presentados por las comunidades indígenas, al conocer sus derechos empiezan los litigios de la mano de organizaciones, pero principalmente la mayoría por parte de las propias comunidades indígenas y sus autoridades y sus organizaciones, en la que la Corte ampliamente ha podido generar una línea jurisprudencial que ha sido muy importante en los diálogos y debates de los pueblos indígenas con el Estado y la sociedad colombiana. Y ahí también algo que se crea en Colombia es esta mesa permanente de concertación de pueblos indígenas y el Estado colombiano, que es permanente, y eso ha generado un diálogo muy grande en el cual los pueblos indígenas hemos podido conocer más del Estado, de la sociedad, pero al mismo tiempo conocer a todo lo que se enfrenta, no solamente los pueblos, sino a generar un diálogo intercultural de cuáles son los asuntos que nos toca trabajar y también entender acá muchos temas. Como decía Victoria, acá hay muchos acuerdos firmados y muy poca implementación, y también los pueblos indígenas se han puesto en la tarea de empezar a hacer seguimiento a esa implementación, e inclusive llegar al análisis de que nosotros ni siquiera estamos en los presupuestos públicos del país, en la planeación de los recursos y en la necesidad de empezar a trabajar asuntos de justicia económica y redistributiva para la agenda de derechos de los pueblos indígenas y el cumplimiento de estos derechos, así como avanzar en el diálogo frente al respeto y la garantía del derecho al desarrollo, digamos, el cuidado de la naturaleza, la protección de los bienes comunes medioambientales que están en los territorios y de los cuales cuidan los pueblos indígenas y conservan para la colombiana. Quiero contar que producto de todo ese proceso, un debate muy grande que existió en el Acuerdo de Paz de La Habana era la exigencia de los pueblos indígenas, afrocolombianos, raizales en Colombia, de que se aprobara un capítulo étnico en el Acuerdo de Paz, porque gran parte de nuestro territorio es el que mayor afectación tiene. Eso nos llevó a la aprobación de un capítulo étnico propuesto desde los pueblos étnicos a través de una comisión que se formó entre comunidades afrodescendientes y comunidades indígenas conjuntamente, que se construyó y se llevó a La Habana, tanto a las FARC como al Estado colombiano, y que producto de eso se incorporó como un acuerdo de paz, el primero en el cual se incorpora en Colombia un capítulo también del proceso de implementación en los territorios étnicos afectados por el conflicto armado, que también lleva como principio que todo el proceso de la implementación del acuerdo de paz tenga la consulta y la participación de los pueblos étnicos en la definición de medidas de trabajo en estos territorios y procesos de coordinación. Y ahí se hace un trabajo de la mano de, digamos, cuando nosotros entramos al sistema, entramos también, porque es parte del cumplimiento de ese acuerdo, incorporar personas de los pueblos étnicos. Nosotros, por primera vez, yo soy una funcionaria, por primera vez, una funcionaria del Estado colombiano de un rango, pues en toda la historia de la República, pues de un rango institucional como comisionada, y muchos otros llegaron a ser por primera vez jueces de la República en el sistema integral, asuntos que no se habían visto en Colombia, no porque no hubieran profesionales étnicos, sino porque la institucionalidad no incorporaba a funcionarios de los pueblos indígenas en los procesos institucionales también de las cortes. Entonces, nosotros consultamos el proceso de justicia transicional con las víctimas y responsables en Colombia. Tiene 3 órganos: la Jurisdicción Especial para la Paz, que revisa todos los asuntos, digamos, de casos de la justicia de la Jurisdicción Especial para la Paz, y ahí ellos desarrollaron un protocolo de articulación con las autoridades indígenas en un proceso de consulta que hicimos como sistema integral. Está la Comisión para la Verdad, en la cual yo estoy, donde construimos una metodología étnica que se denomina la metodología étnica contra el racismo, la discriminación racial y otras formas conexas de intolerancia, de la Comisión de la Verdad, que se hizo también con la participación de la consulta de las comunidades indígenas y el pueblo gitano. Y hay un protocolo de coordinación entre autoridades indígenas y la unidad de personas dadas por desaparecidas. Esta experiencia de articulación ha sido bastante importante y de participación con las autoridades étnicas, autoridades indígenas y en este caso la Comisión de la Verdad, de donde yo he estado trabajando estos 3 años. Primero porque los actos de reconocimiento de responsabilidades han generado, o sea, un diálogo entre las víctimas de los pueblos étnicos, sus autoridades, y ha permitido la reconstrucción histórica de los actos y hechos que se dieron en el marco del conflicto armado en sus territorios, permitiendo, digamos, romper con la historia colonial del conflicto armado y permitiendo reconocer la conflictividad que existe en el país, que tiene raíces de digamos, del trato colonial y de la discriminación racial en estos territorios, porque pues en Colombia existía o existe un relato del conflicto que en las ciudades se centran mucho en todo lo que son los debates que se dieron y se han dado de la Guerra Fría, pero aquellos, digamos, análisis del conflicto de las comunidades rurales negras e indígenas han estado ausentes de ser partícipes de ese relato del conflicto, lo que no le ha permitido a la sociedad entender en qué ha mutado el conflicto y cómo se ha generado el conflicto y la desproporcionalidad del conflicto en los territorios étnicos. Entonces, consideramos que este proceso ha sido importante, sin duda, porque permite incluir la narrativa étnica del país por primera vez en el relato de la República también, superando los relatos coloniales que existen sobre los pueblos indígenas y los pueblos afrodescendientes en Colombia. Entonces, solo ya para terminar, hay una frase que los pueblos indígenas, y yo la llevo conmigo, por eso decidí estudiar Derecho y muchos años después fundar una organización de abogadas mujeres indígenas. Y me acuerdo mucho que el primer mandato de Congreso de los Pueblos Indígenas de Colombia, yo estuve bebé en ese congreso, pero digamos cada 4 años participé y me fui creciendo en esos congresos, que son los espacios nuestros para legislar como pueblos indígenas y hacer mandatos a las autoridades tradicionales nuestras. Y ahí un primer mandato que llevamos con nosotros era que dieron los pueblos indígenas en su congreso, era que mandataban a los pueblos indígenas de Colombia conocer los derechos, que era necesario conocer los derechos todas las autoridades y exigir su justa aplicación. Y creo que eso es muy importante en los procesos digamos, de avance, de exigibilidad, sin duda para los pueblos indígenas, la importancia de que conozcan y apropien sus derechos y hagan todos los esfuerzos, tanto jurídicos como pedagógicos como políticos, para que estos derechos puedan avanzar. Y creo que sin duda, sin esa digamos, ese trabajo consciente y diario de los pueblos indígenas por lograr el reconocimiento de sus derechos, sería imposible pues que solamente una acción jurídica sea suficiente, pero sin duda la acción jurídica es resultado de todo ese, digamos, esa apropiación y aplicación de ese reconocimiento de derecho. Eso sería lo que yo podría compartir en esta reflexión. Muchas gracias.
Thank you very much, Patricia. I'm so glad we've been able to hear these stories direct from your experience working with Indigenous community members in Colombia. And I particularly appreciated your conclusion at the end. I think that's something we can all keep in our heads as we continue within this work. So that now concludes our speaking panel. And I'd like to open the floor up for questions. We do have a few that have already been submitted, and I'll do my best to field those that have been coming in. Maybe I'll turn to Daniel Kobei first. There's been a specific question for you and also a question for all the panelists. So Daniel, firstly, could you talk a little bit about the Ogiek case? So the current situation of the case, the current political will to implement the ruling, and the next steps. And then also a question to all the panelists, and perhaps to you, Daniel, first. How do you understand the coalition between Indigenous movements and other social movements in building community justice programs? How do you think Indigenous movements can be responsible and help in building community justice? Thank you.
Thanks, Lucy, for that, and thanks for my fellow panelists. I think my first issue is that to understand about social movement and the indigenous movement, it is one and the same thing. It is only that it is more specific or biased towards indigenous peoples, whereby the indigenous peoples' issues have their unique issues, as Vicky had already mentioned. Issues related to FPIC and how we interpret them, they might be different, but the other social movements are linked to issues related to human rights and such like. So I may not speak much about that. Maybe Vicky or Patricia can speak more. But let me say that the current situation of the Ogiek case is that, yes, there is a political will to implement, but it is misinterpreted. The way the case is interpreted among the government people differ. When I meet government officials about the implementation, they say, oh, the court has given you land. But now they are not telling us how, because they say, oh, the case says you are going to protect the forest. You will be the people to protect the forest. You will be the people to be part of the forest issues. We're not necessarily talking about the ownership. We're not necessarily giving Ogiek a chance for FPIC to discuss how their land, how the holding will be done. So when they were doing when they were doing the task force and the way we made a presentation, our request, instead they just want to do the implementation on their own will, on their own interpretation. They seem to lack the know-how on how to interpret the way the case was put. And we believe, as we are now waiting for the hearing of the reparation, which will be done in the month of June, hopefully. I hope those things will be ironed out so that the specifics on how the case will be implemented will be clear. Unlike when anybody reads and say, can you show me in this judgment where it is saying you should be given land? And you know, it is just lack of the know-how on how the government should be able to give the right people and with the people with the knowledge on how to interpret, not just a government officer who is an administrator by training. He knows how to protect and bring peace among the communities, but he has no know-how about the knowledge of land, on how issues of indigenous peoples. Many times I'm being asked, why do you want to say indigenous people? What is so unique about you? We are all indigenous, and this is a challenge we have in Africa. Despite the fact that the working group of indigenous peoples have already described and given definition on who are indigenous peoples in Africa, which Ogiek is listed as one of them. And indeed, the case even gave a very strong ruling saying the Ogiek are the indigenous peoples of Kenya. So this lack of interpretation and the will, as the situation is, and the worst of it is that some government officials say, we cannot settle Ogiek alone. You should be settled by everybody else, like everybody else. We say, yeah, we have no problem. We have not gone and settled in other people's territories. The uniqueness of Ogiek and the ancestral land seems to be lacking. The issue of Ogiek ancestors and the other ancestors, we cannot mix the same, but the government feel, no, everybody should be the same. And that, well, we agree, we have no problem about your win for the case, but this is how it should be. And also the lack of assurance that the Ogiek also can participate in restoration and conservation. Then traditional knowledge, they seem not to believe that Ogiek can protect. Instead, you could find in media they are saying, oh, Ogiek are part of the destruction, without giving them a chance to explain themselves. I may talk long, Lucy, but let me leave it there. Thank you.
That's great. Thank you, Daniel. Turning maybe to Vicky next. One of the questions has come in is around the strategy of national human rights institutions in countries to support Indigenous peoples and/or with ombudsman's institutions. Do you have any comments on the roles that these organizations and institutions can play, either from your work in the Philippines or more from your global international work, in terms of supporting implementation of rulings, but also in empowering communities as they seek justice?
Thank you for the question, as well as the earlier question that you raised. Definitely, I would certainly say that the national human rights institutions, though, have a very important role to play, in supporting the implementation and the recognition of the rights of Indigenous peoples. And in the case of the Philippines, for instance, the Commission on Human Rights have been very much involved in helping disseminate the information on the UN Declaration on the Rights of Indigenous Peoples. I remember when we were at the point of getting it adopted by the Human Rights Council, the chair of the Commission on Human Rights organized a meeting between me and the commissioners of the Human Rights Commission, so as well as the judge, the advocate, how do you call it? This is the justice of the job of the justices of the government, for me to explain why the declaration has to be adopted by the Philippine government, because they raised a question during the adoption process saying that, this can undermine the national sovereignty of the Philippine state. So I had to explain that national sovereignty doesn't mean that you have to exclude those who have lived for centuries in their own lands and who have a big say, who should have a big say over how the government is making decisions related that will directly impact them. Similarly, in other countries, the ombudsman, I remember in Guatemala, they also have a very strong ombudsman. Even in Colombia, as well as in Brazil, I met with the human rights commissions, and they are very sensitized to this. But I'm not saying that every commission on human rights is like that, because there are certainly commissions which are not yet aware about these rights. So there's a lot of work that needs to be done to involve them. I remember in Kenya as well, the Commission on Human Rights in Kenya, the chair of the commission usually goes to attend the UN Permanent Forum sessions during the times that I was chairing the session. The other question in relation to the social movements, the role of other social movements, I would say that there are indeed the social movements have a very big role to play in terms of supporting Indigenous peoples, the movements of Indigenous peoples. But we also cannot be naive to say that everything is good, because there are also cases where some movements or groups have really contradicted the implementation of the rights of Indigenous people. I can say India, for instance, when there was this Forest Rights Act, which was going to recognize the rights of forest peoples and Indigenous peoples to stay and manage the forest, there was a strong response, from some of the environment organizations refusing to have that particular reference in the law. And even when there was a Supreme Court, they also filed a case in the Supreme Court which sort of would like to remove that particular provision. So there are cases where there are some tensions, and that's the reason why we also always mention intercultural dialogues, because those dialogues should be held between Indigenous peoples and other movements, but also between Indigenous peoples and the state, as well as with the business sector. And I strongly recommended in my report reports on self-determination and autonomy, that these intercultural dialogues have to be done and institutionalized, and the place of indigenous peoples in those dialogues have to be very visible. Thank you.
Thank you, Vicky. And intercultural dialogues was certainly something that both you mentioned as well as Patricia. So turning to Patricia next, one of the questions is around, in addition to implementation of favourable court judgments, which both you and Vicky and Daniel have mentioned the importance of implementation. What do communities see as wins in these legal strategies? Are there other important factors within litigation that also play a role within legal empowerment? Thank you, Patricia.
Bueno, gracias. Bueno, yo creo que un proceso de exigibilidad de derechos parte de fortalecer las capacidades también aún más de las comunidades. Esos son esfuerzos muy grandes en el cual sin duda la comunidad se compromete, pero también aprende de sus derechos. Ya las comunidades en sí, sin conocer esos derechos, saben que tienen esos derechos como pueblos, que los reclaman. No es extraño que uno vaya y les diga, además de eso tienen estos derechos, ellos lo tienen claro que esos son sus derechos milenarios. Pero al tener estos derechos y al tener estos mecanismos, ellos también se fortalecen bastante, porque también en esto se generan unos diálogos en las que también nosotros en esos diálogos las comunidades logramos también generar una pedagogía, poner estos temas de lo que significan nuestros territorios y nosotros mismos en todo el país, porque producto también de ese trato colonial la sociedad nacional no conoce de nosotros como pueblos indígenas e inclusive está educado para hacernos daño todo el tiempo. Entonces se vuelven estos procesos judiciales espacios de debates públicos también y debates en los cuales también a la sociedad, a las instituciones, los jueces le han dicho hasta aquí es su límite. Y estos son los derechos de los pueblos indígenas. Entonces, muchísima gente no conoce sobre los derechos de los pueblos indígenas, pero sabe que los indígenas tienen derechos, entonces, por estas sentencias. Entonces, creo que esto nos ha ayudado un poco a que cuando los pueblos indígenas exijan que los escuchen, exijan una participación, haya por lo menos, digamos, que sean escuchados. Ahora, en el cumplimiento nos falta muchísimo por hacer y nosotros en estos diálogos hemos aprendido mucho como pueblos indígenas, como autoridades, como personas que estamos al frente de estos debates, muchísimo, cosas que no entendíamos antes y que ahora cualificamos en todos estos debates con la sociedad nacional y las instituciones, afinamos mucho más nuestros debates intentando también lograr hacer una incidencia real y concreta. Muchos de nuestros discursos de hace 20 años los escuchamos y hoy escuchamos los que tenemos después de los debates y uno se sorprende bastante porque digamos, hay más argumento, además de los que traemos como comunidades de nuestros conocimientos. Ahora ya también trabajamos estadísticas, hacemos líneas de base para poder llevar y mostrar los problemas que tenemos y presentarlo y que la sociedad los pueda entender. Detectamos problemas de fondo que tiene el sistema como tal, como sociedad, por qué no nos entiende, y también eso nos permite decir, por ejemplo, el currículo educativo del país se tiene que transformar, tiene que integrar las narrativas étnicas y no nos puede seguir haciéndonos ver como los atrasados en la civilización. Nos tiene que dar esa reparación histórica para que la sociedad se pueda educar en referentes distintos porque finalmente el funcionario público y la política es un reflejo de una sociedad, una cultura que históricamente ha nacido con una idea cultural de la conquista, la colonización, y ese es un mal que ahí está en la sociedad, en muchas sociedades, y ahí, por ejemplo, la agenda indígena está en este momento debatiendo muy seriamente esto con las instituciones y los gobiernos y con la sociedad. Entonces creo que hay cosas que son importantes, que también nos han dicho como pueblos indígenas, nos dice mucho, no, es que es la colonia y esa colonia, ¿quién la va a remover si son tantos años, si son tantos años de poder y eso no, nunca se va a quitar? Y yo creo que sí se puede quitar, ¿no? Que sí se puede quitar. Y nos hemos quitado algunas cosas y creo que los pueblos indígenas han ido logrando y siguen luchando. Hemos logrado padecer muchos periodos de la larga colonia, pero es necesario poder, y la colonia no se ha superado, sigue teniendo esas relaciones y requerimos entrar en un diálogo moderno también. Y creo que estos procesos nos ayudan mucho a fortalecernos y a cualificarnos como comunidades en esos trabajos. Y sin duda, a integrarnos también y a ser parte de... Yo no venía de procesos estatales, yo siempre estuve en las organizaciones indígenas. Y en mi experiencia como comisionada, yo le decía a las autoridades indígenas, la diferencia mía es que yo vengo del mundo indígena, pero la diferencia de algunos otros funcionarios que vienen de los partidos políticos, yo le decía, nosotros tenemos que exigir nuestros derechos a ser parte de una institución sociocultural que reconozca nuestras instituciones y que nuestras instituciones puedan poner ahí personas que defiendan nuestras voces también y eduquen a funcionarios y a la sociedad, que no se extrañen que somos así, que hablamos así, y que aprendan a reconocer que nosotros somos parte de su realidad, y puedan convivir con nosotros en medio de esas diferencias. Y creo que estos derechos ayudan bastante a abrirnos esos caminos que estamos intentando desde hace tanto tiempo y históricamente como pueblos indígenas.
Thank you very much, Patricia. Just as we've got a few minutes more before we wrap up, and some of the questions that came in advance of the webinar actually looked at the issue of gender justice and Indigenous women's and girls' rights. Daniel, I wonder, you had that fantastic picture of Ogiek women marching for justice within your presentation. I wonder if you could talk a little bit about how particularly Ogiek women, Indigenous women and girls have been, their rights have been advanced within the Ogiek litigation.
Well, I think in my presentation, I made a lot of repetition about the strength of the women and how the women played a big role. One great thing you could, in these third world countries where corruption is mushrooming every day, women are more or less, or they are less corrupt and they cannot easily be corrupt. And many times when there are government in issues who wants to split the community to their interests, it is only the women who always remain strong. And secondly, the assurance that land will not only be for the Ogiek men, it will be for all. That gave also that kind of strength or the leverage to the women to continue fighting. And the many forums which we have had with the support of partners in advocating and sensitizing the women and the young men and women on the issue of the land and their rights has also given the strength to the women. And that in the process, they have played a role and giving us hope and pushing us to continue fighting and fighting. And they always do it using folk songs. They use all kinds of ways to ensure they convey the messages. And if you recall, one of the times you visited Kenya during your time, you could see how women have that kind of motivation to continue saying, we will not relent until the rights of Ogiek is realized.
Thank you, Daniel. Vicky, in your work globally, can you think of any particular examples, particularly as a women's rights advocate, where Indigenous women's groups have really been able to advance their struggle using legal frameworks and methods that are available?
Yes, well, there are several formations of Indigenous women, both regionally and globally. We have FIM, which is the International Forum on Indigenous Women, and this is one of the bodies that has really pushed strongly for the participation of women in every process, that has direct impact on Indigenous peoples. And one of the recent things that they have achieved is to get the CIDO, the Committee on the Elimination of Discrimination Against Women, to make a general comment on Indigenous women, because for a long time we have been asking for this, and now the committee has finally decided to make one, and they are drafting they are making some drafts which they are sending to Indigenous women to comment on, and that is going to be important because there are many cases that Indigenous women also would like to bring to the attention of the CIDO, of the committee, and hopefully this will also further heighten the legal empowerment, strengthen the legal empowerment of Indigenous women themselves. There have also been there have also been cases filed before the CIDO, by Indigenous women themselves. So that's one. But the other thing is also to provide support for them when they are subjected to, to human rights violations. Like in some cases, there are cases where Indigenous women leaders are criminalized. They are labeled, they are vilified, and there are charges against them. So what some Indigenous organizations have done, like the new one, the Indigenous People's Rights International, is to provide sanctuary funds and legal funds, to these women, so that they will be able to bring their cases before the courts. And I think that's really very important. Indigenous people don't go to the government courts because they don't have the resources. It's very far. It's only with the support of people who are willing to give them the resources, as well as provide them resources to be able to have translations done, because what I have seen in many cases that Indigenous women, even Indigenous people in general, they don't go to the court and the dominant language is the one being spoken, and so they cannot participate, and even so the issue of interpretation and translation is very crucial for Indigenous women to be able to access justice as well. A lot of Indigenous women are illiterate. There's a very high rate of illiteracy, and so that kind of situation has to be put into consideration, has to be taken into account when we bring these Indigenous women to such justice systems. Also, the other thing that before I forget, there are also Indigenous justice systems that exist. In the past, many of these justice systems are also male dominated to a certain extent. But in some countries, I've seen that Indigenous women have also became part of some of the justice authorities. In fact, in Ecuador, I visited some justice authorities who were imprisoned, and two of them were women, and so. And we can see Patricia. Patricia, for instance, is a very good example of an Indigenous woman who has been legally empowered, and she is now part of the system of trying to bring about truth and to implement the Truth Commission that's a result of the peace agreement.
Thank you, Vicky. I'd like to give Patricia just 1 minute to add any thoughts to that. I'm aware that we're just coming up to time. We started very slightly late. So, Patricia, is any thoughts from you on what is needed to further strengthen legal empowerment, further strengthen gender justice? Quickly. I think you might need to unmute yourself, Patricia.
Unmute.
Son muchos los retos. el tema de justicia comunitaria, étnica e indígena requiere casi que un diálogo porque requerimos mejorarlo, porque gran parte del mundo global tiene pueblos étnicos y si las justicias comunitarias no mejoran en términos de reconocimiento de sus derechos, pero también mejorar estándares y que haya una coordinación con las justicias nacionales, es muy difícil que las mujeres en lo territorial accedan también a sus justicias, o sea, accedan a una justicia en términos de derecho. Eso es algo que es importante porque creo que, por ejemplo, el sistema de Naciones Unidas debería tener un tema dedicado a justicias comunitarias porque es la mayoría de la justicia a la que realmente acceden los pueblos étnicos y muchas de ellas no tienen fortalecimiento ni garantías institucionales, no son respetadas ni reconocidas por sus sociedades nacionales y creo que ahí hay un asunto bastante importante porque desde esas experiencias no solamente se resuelven, sino que son fundamentales para el acceso a la justicia de muchísimas comunidades étnicas e indígenas en el mundo y en los países de donde nosotros venimos. Sin embargo, pues hay avances también como los que se han contado aquí importantes. Gracias.
Okay, thank you, Patricia, and thank you, everyone. This concludes our webinar. I'd just like to respond to one question which came up on the chat, a very kind question, thanking us for the webinar and asking if there are any plans for others in the next months. So please do keep an eye on our websites, that's Forest Peoples Programme, Indigenous Peoples' Rights International, and also the NYU Global Justice Clinic. Keep an eye on our website, FPP newsletters, and others, our social media, and other webinars which are coming up will be advertised. Thank you. So finally, I'd like to thank all the speakers for joining us today and to everyone for participating. The panel have very clearly shown us how Indigenous communities can centre themselves in their own fight for justice and how this journey can empower them to know, use, and shape the laws that impact their lives. Thank you. You're an inspiration to us all. Have a great day.
Thank you. Thank you very much. Thank you. Okay.